Welcome to another video, guys. Thank you for joining me again. I just have some exciting news about things that I've recently just discovered. I want to share with you. But I've been away for a while, and uh, I was basically just going through a transition, especially in my career. So I couldn't really. I was completely busy. I was swamped with my new path that I'm following. But I'll explain it another time. But now, what I want to talk about is the new directive that was instituted by the International Labour Organization, the body that we all, as the entire world, is governed, like the United Nations. The International Labour Organization is a branch of that. So uh, the issue that came was the issue of the strike action. So it was always been ratified in the convention. I think it's Convention number 58 of the International Labour Conventions, and South Africa is party to the International Labour Organization. So what happened was about 14 years ago, there was two schools of thought in terms of what does a strike mean? What does strike action actually mean? So, and then the the International Labour Organization went to the International Court of Justice to get an advisory opinion on the matter. And that ruling just came out. I'm just going to share that with you. I think it's very important. Now, in South Africa, the definition of a strike is in terms of section 213 of the Labour Relations Act. Let us just go there and see what the strike action is. Okay, let's go to the definition of what a strike is in terms of the Labour Relations Act, and then we can circle back to what the advisory opinion is from the International Court of Justice in relation to a strike. Okay, so in terms of the labor, remember South Africa is a signatory to the international conventions, and everything you find here stems from the international labor organizations guidelines that we all have to follow. So you will basically find most laws in all countries are similar to the guidance that's set by the International Labour Organization. But let's go to our legislation in terms of the Labour Relations Act. Let's have a look at what the definition of a strike is. Okay, so the definition of a strike means the partial or complete concerted refusal to work or the retardation or obstruction of work by persons who are or have been employed by the same employer or by different employers for the purposes of remedying a grievance or resolving a dispute in respect of any matter of mutual interest between employer and employee, and every reference to work in the definition includes overtime work, whether it is voluntary or compulsory. So that is the definition of a strike. In other jurisdictions, the strike action is not really defined, but in terms of the International Labour Organization, um, there was two schools of thought. Like I said earlier on, it was from the employer saying that strike doesn't actually mean down tools and withholding labor. They did not see it that way, even though it was expressed in the convention. I think 58 of the convention that they speak about strike or industrial action, but the workers, in terms of the what the workers say is that it's the true definition of a strike is for us to be able to withhold our labor as a tool of bargaining with the employer. If that's right is been taken away from the employees, then they don't really have bargaining power, which means the balance of power will always be skewed in favor of employers. So employers were pushing back on this aspect of strike. So then that was 14 years ago. So 14 years later, I think last month, for the first time, the ILO referred this matter to the International Court of Justice to give us an advisory opinion on this issue. So I'm just going to read you an insert of what was said in terms of this advisory opinion. The UN International Court of Justice ruled in a historic advisory opinion that the right to strike is protected under the International Labour Organization freedom of association and protected. The UN International Court of Justice ruled in a historic advisory opinion that the right to strike is protected under the International Labour Organization freedom of association and protection of the rights to organize convention in terms of 1948 convention number 87. So in our legislation also, in fact, in our constitution, there is a whole clause dealing with freedom of association and freedom of association. It means that you can join a trade union, and the effect of joining a trade union, you are associated with a trade union, you belong to a trade union. The employer can't actually uh, discriminate against you for the fact that you have now joined the trade union. And obviously, uh, trade unions can organize their members to strike. So that is where the freedom of association aspect comes in. So then, yeah, we see here that this landmark decision effectively resolved a massive year stalemate between global workers and employer representatives in the ILO. Now, the core issue, although Convention 87 does not explicitly use the word strike, the ICJ ruled that the right to strike is inherently protected as a core activity for defending workers' interests. You see, that's what I mentioned earlier about definition, but we in our country have a definition, but in the ILO, that definition was not really clear. So it was a massive back and forth between the two, and was the ILO conferences was quite heated on this specific aspect of the issue of a strike. So I think I need to bring this to your attention so that you can know the importance of strike action. Um, you know, you guys don't really realize the power that you actually have when you exercise your rights. And that's the purpose of my channels, for you to be able to learn from me so that you can enact these things in your workplaces. And if you're more informed, you will be able to make better decisions in relation to your conditions of service in the workplace. So it goes further to say here that though this advisory um, is technically non-binding, the ruling acts as an the ruling acts as an authoritative interpretation for the 158 countries, including South Africa, that have ratified this convention. Remember, I said we fall under this convention. So, so the International Labour Organization is going to take this advisory um, opinion into consideration in amending further conventions so that this issue can be put to bed now, and I think it's important for you guys to be able to imagine now you could not strike. Imagine now you means you will never be able to ask for more wages. They mentioned earlier something about mutual interest. Now a mutual interest dispute is something where you don't have a right, but it's something that you would like to have. If you want to learn more about mutual interest issues, just click on the link of one of my previous videos, and you will be able to get the information about that. This is collective labor law is one of my favorite topics. I enjoy that much more than individual employment law, which I deal with on a daily basis. And collective labor law is not something that is people don't really have much information about that, and I'm going to try my best to give you as much information as possible about this issue, because I also have trade union background, uh, as experience, I've rose up the ranks in the trade union movement. I was a normal employee. I noticed that things didn't work right in my workplace. What I did is I consulted my union, and then I told them, look, I would like to be a shop steward. What can I do to be able to become a shop steward? Then the process was explained to me. I made that happen. I became a shop steward, and then after that, I rose up the ranks, becoming a office bearer. So I've been a chairperson for my structure in the province in where I come from, and I have went to national meetings to raise the issues of the plight of my people that I used to represent at the national level, so that when the people at the bargaining forums, like they call it chambers, they will be able to know what the issues is, so that the bargaining chamber between the trade union and the employer, those issues can be ventilated. Those type of things that I would like you for you guys to know. But I'm going to deal with that in future with regard to collective labor law. If there's any other questions that you have in relation to uh, in the collective labor law, uh, please put the questions in the comments, or I have my contact details is in the description below on my page. Just send me an email, and then I'll try my best to reply. I will be more active. Nowadays, I've not been active for a long time, but I feel it's important for me to just get back on doing the things that I love, and sharing information. Although the body of work that I've done over the years, I would like to explain and share it freely with you. Thank you very much for tuning in. Don't forget to like and subscribe to my channel, and I'll catch you guys in the next one. Thank you very much.